3 years, a practice has been developed in Calcutta High Court with great respect to all the judges. Whether even that matters have not been settled, decided as yet. 3 years of the country to run to Supreme Court and file an appeal. Question is not there. Really it's a alternative remedy, efficacious remedy or not. Well, leave aside everything. Here state has come up as an appellant. Earlier cases, very rich persons, powerful persons, Sukhendu Adhikari had prepared an appeal. Anyway, it's not maintainable in a matter, in a writ petition. Shall I start again?
Yes, yes. Can you just...
Yes, Milord. What has happened, Milord? He kindly come to Milord the prayer of the writ petition.
That is what I was just looking at, page 55.
55. Asking for quashing of the investigation, etc. in the proceeding. But more particularly, he has said in the paragraph 25 of that is at page 36. Page 36. The petitioners have approached this honorable court seeking for quashing of the FIR on the ground that the state case reek of malicious and malafide approach, which is palpable from the narration of the Swans. Now, Milord, against the learned single passed an order.
We have annexed it with the supplementary affidavit.
Yes. Give it a copy of the
The order is also there. The
order dated 11.
The
correct, Milord. Learned advocate appearing for the petitioners challenging the continuance of the Bhatpara police station case number.
Another notice be issued. Another notice be issued on for 1811.
Yes, right. Against that order, he has filed this. Now, I took the point, Milord, whether the maintainability of the appeal itself. Last week, I have argued that. Milord, that kindly, just to remind to your lordships, Milord, just take the judgments, Milord. I have handed over the judgments. Ramkishan Fauji and two Calcutta High Court judges.
Suparna Kanjilal Chakraborty and
Suparna Kanjilal Chakraborty there, your lordship, Suparna Kanjilal Chakraborty was there, State of West Bengal there, etc. And other side was Mr. Mojumdar. He had taken the point that is not maintainable. His leader was there. On behalf of Shubhendu Adhikari, they had taken the point that not maintainable. It was not maintainable. Hold it. Now, this has been two judgments have been held that the order passed in a writ petition which is criminal in character. The forum
criminal flavor.
Then the
latest patent, there is no
especially in the case of a quashing and etc. There are two arenas have been divided by the Honorable Chief Justice in another matter. Police inaction, transfer of investigation. That's a different issue. But when you are asking for quashing of the proceeding,
then you have a letter patent with us.
Yes.
My lord, your lordships kindly, your lordships will find from the Ramkishan Fauji itself.
This is
no. What is that clause?
My lord, clause 15.
My lord, also see clause 40 and 41.
Just 1 minute.
Now you say that the judgment is wrong of the Shubhendu Adhikari's matter. No, you say, I don't have any difficulties. But State of West Bengal, when will come in appeal, will say not maintainable. And when you will not get the order, you will say I am not maintainable. But I have no difficulties. But once for all, it has to be decided. Because of Shubhendu Adhikari, it is not maintainable, it will be held. But because of the state, it will be maintainable. That cannot be the criteria. That time he will come. You are the persons who have said this. All you are the persons who have curtailed this. Fundamentally, I feel that there should be an appeal. And every time it is not possible to go to Supreme Court, that I feel it. But you have curtailed this. Appearing against the state, that time you are all vociferous. 15 councils will come from Delhi here, not maintainable, etc., etc. Manoj, kindly come to paragraph 17 of the Ram Fauji's case. Fast.
No, I just, Mr. Bandyopadhyay, as my character goes, I want to look at the provision of law first.
Huh?
Then I will go to the judgment.
No. Here the judgment this has been quoted. That's the reason. Exactly, that has been quoted.
Clause 15.
Clause 15.
Yes. Give us 130 seconds.
Yes.
From the civil courts of emergency. The bad one.
No. Where is the book?
That there is a typographical error. I do not know from where you got it.
But we have from internet we got it.
No, that is what is the problem.
24, 25.
Absolutely typing mistake in clause 15 itself. Should be with them. What is this?
We shall bring it, Milord. We shall bring the book.
Where it is quoted.
Milord, kindly come to first your lordship. Just Sri Ramakrishna Fauji, first your lordship come to paragraph 17. Lahore High Court's.
So that is the.
Milord, then the Supreme Court has said is a parameteria. Kindly read Milord paragraph 17. Appeal to the High Court from judges of the court. And we do further ordain that an appeal shall lie to the said High Court of Judicature, allowed from the judgment not being a judgment passed in the exercise of the appellate jurisdiction, in respect of a degree or order made in the exercise of the appellate jurisdiction by a court subject to the superintendence of the said High Court, and not being an order made in the exercise of the revisional jurisdiction. Revisional jurisdiction. 15 to that. 1 minute. See clause
23.
Just similar clause 23 of the latest spirit of our High Court. There the question lies, according to me. Similar, kindly excuse me, only one. Extraordinarily original criminal jurisdiction.
No.
23?
23 is a jurisdiction of the.
Anyway, kindly see 23, next 24, possibly.
24 is extraordinary or original criminal jurisdiction.
Original criminal, candidate. I don't know why it's not telling. It's the latest one, or I don't know. And we do further ordain that the said High Court of Judicature at Fort William in Bengal shall have extraordinary original criminal jurisdiction over all persons residing in a places within the jurisdiction of any court, now subject to the superintendence of the Sardar Nizamud Adalat at
you are reading something else. It is not there in the book.
This is
sir, আমরা রিলাই করছিলাম. This is not correct. এই বইয়ে
can I
please look at that 24.
Yes, sir.
কোথা থেকে সব আসছে এগুলো তাহলে?
Look at this 24 you have handed over. Devani Sadar Adalat
চেঞ্জ হয়ে গেছে.
been omitted.
হাইকোর্ট হয়ে গেছে.
I tell you, Mr.
All right, can you just 24 is extraordinary criminal, original criminal jurisdiction. अच्छा বই আছে দিছো?
Yes, yes.
Extraordinary criminal jurisdiction. Yes. On we do further order that the High Court of Judicature at Fort William in Bengal shall have extraordinary original criminal jurisdiction over all persons residing in places when the jurisdiction of any court now subject to superintendence of the High Court shall have authority to try it at his discretion any such person proves to consider. Now 25. And we further ordain that there shall be no appeal to the said High Court of Judicature at Fort William from any sentence or passed or made in any criminal trial before the courts of original criminal.
That is what I'm saying. That has been abolished subsequently. What you have better experience than all of us. Being a more veteran in the profession. Previously, the High Court used. High Court had a power to conduct a session trial. So that was there. They used to.
I know.
You have seen that.
I know.
Last one I saw. You must have seen more.
No, one was only one for years.
So that is you saw also, and we saw also jury trial and all. Everything was there. Later on, this has been abolished. And that has been taken to district court for that. So these were the provisions initially that the High Court was exercising the original criminal jurisdiction.
Correct.
But the difficulty I think Ramkishan Fauji is there. There's no doubt about it. But the trouble is because, as you know,
yes,
expressed very clearly
correct.
to have a proper assistance
Correct,
from you, all of you.
Correct.
But Justice Radhakrishnan, in a subsequent judgment, that is in Gopal Kumar Agarwal,
Correct.
he considered Ramkishan Fauji.
Correct.
What troubles us is two things. Please enlighten us on that.
Yes.
He interpreted Ramkishan Fauji in a particular manner and ultimately arrived at the conclusion at paragraph 27. He says that yes, the appeal would not lie, but in what situation? The situation is if there is a quashing of the criminal proceeding, or by virtue of an order passed by the court to initiate a criminal proceeding, then in these two situations, appeal would not be maintainable. Means only against the final order quashing the entire proceeding, right? Not against an interlocutory order which is passed. And then paragraph 28, he held that appeal is maintainable.
My lord, kindly read. Please read. Paragraph 27.
27.
We have no disagreement. We have no disagreement with the proposition of law propounded in the aforesaid decision.
Yes.
However, in the facts of the present case, the order of the learned single judge neither resulted. Correct. See. Neither resulted in initiation of the criminal proceeding, nor in quashing of a criminal proceeding. The facts of the instant case from the facts of the Delhi case discussed above. This is
28.
For the efforts we hold that the present appeals are maintainable and not barred by clause 15 of the latest patent 1865. Now the merits are now let kindly come. Then one has to take which judgment I will take. Ramkishan Fauji has been clarified. Kindly come then.
Paragraph 22. Please come to paragraph 22 of that judgment.
The facts of in the case of Ramkishan Fauji are different from the facts in the present case. In that case, the learned single order had a consequence which was clearly criminal in nature. The learned single judge opined that the recommendation of the Lokayukta for registration of FIR against Ramkishan Fauji deserved to be quashed and accordingly quashed the same and also quashed the action taken pursuant to such.
This is what a distinguishing feature he brought. That suppose in the instant writ petition, I am telling you, there are two situations that may come. Either the court will dismiss the writ petition saying I am not going to quash, or the court may quash it, saying that I am quashing the FIR. There are two situations because first prayer is like that, quashing of the proceedings. So either of these will come. Suppose, just out of sheer exchange or view,
my lord,
if he quashes it, no appeal. Then Ramkrishna Fauji says no appeal lies.
Correct.
But if he refused to quash, then the Justice Radhakrishnan's view was that it does not create a fetter in maintaining the
correct.
Because in Ramkrishna Fauji, the criminal proceeding was quashed. And thereafter, this is what a distinction in paragraph 27 comes. Please correct me.
Yes, my lord. Yes.
My mind is still open.
Correct. I understand. I will tell you, Lord. I correct. Finish. My lord, can I start now? See, let me first
on a maintainability, Mr.
No. I tell you, my lord. Let me first express my view, then I will come. But my view is this. My personal view is this. Of course, take it as a personal view reading in this.
Then let us.
My personal view. No, doesn't matter. Let it. That's why I am talking about law. I am talking about law. I am not talking anything. Every lawyer has his own reading. Every judge has his own reading. Interpretation of the things differs from man to man. Today, Ramkishan Fauji is there. Tomorrow, any other bench, 5-year-old Ramkishan Fauji is not correct law. These are we have seen that. In an article 226, it's a right for establishment of the fundamental right or constitutional right. Breach. Broadly, I am talking about broadly. This is available to High Court. Very recently, I did one matter, my lord. I am taking cue. I will tell you the sentence which has been used by the Supreme Court in that matter. High Court entertains 226 is the original jurisdiction. 226 civil, criminal, etc. Now, my lord, last few years, fortunately, unfortunately, a practice has been developed because of Arnab Goswami's case, entertaining, quashing of the proceeding, granting bail, and Calcutta High Court has given past so many orders. No coercive stays, other way the bail is given, anticipated bail is rejected. Now the point, now it has come. Earlier it was not there. Earlier either, because it was very difficult in Calcutta High Court to entertain a writ petition is in very rarest cases is entertained when seeking for quashing of the criminal FIR, etc. Because everybody, if you have a case, go to 482. But anyway, last 3 years, a practice has been developed in Calcutta High Court with great respect to all the judges. Whether even that matters have not been settled, decided as yet. 3 years, 4 years, one is enjoying. Now the point, the interim order, don't arrest. No court system. That means what? You are exercising the power of the anticipated High Court's jurisdiction. Therefore, question is, other way it can be done or not. It was not there. Now, although High Court, under Article 220, there is no bar to entertain a writ petition questioning the FIR. No, there is no bar. Bar would be exercised or not, power would be exercised or not is a different matter, but power is exercised. Now, interim order has been passed in a criminal proceeding. I mean, quashing of the proceeding. When a writ has been entertained, interim order has been granted. Against that, when an appeal is filed, Calcutta High Court is saying no appeal is maintainable. Granting an interim order, non-granting an interim order is equally standing on the same footing or any direction has been passed. Question is whether in an interlocutory stage, even an appeal is maintainable so far the criminal jurisdiction is concerned. When you are exercising power, but my personal view is, chance should be given to the litigants. Very recently, I did a case on the basis of a Supreme Court judgment challenging the order, of the National Green Tribunal. And the Supreme Court has already decided, yes, National Green Tribunal's order, writ is maintainable. Writ is maintainable. Reasons have been given for that. One of the reasons I am saying, that it is not possible for the peoples of the country to run to the Supreme Court and file an appeal. Question is, there, really it's a alternative remedy, efficacious remedy or not. Leave aside everything. I hear state has come up as an appellant. Earlier cases, very rich persons, powerful persons, Sukhendu Adhikari had prepared an appeal. Let down in Ramakrishna Fauji and subsequent thereafter, it has created a bar. Now, let me read the Ramakrishna Fauji's case. Leave aside my personal view. Now I am coming. Please, Mr. Majumdar, I know little bit of the things. I know little bit of the.
No, I'll appear. I will clarify the position.
Every time all you, kindly see, against the judgment of the Justice Talukdar, SLP was preferred by state. That was not entertained. Two reasons are there. What has happened, my lord, against the single bench order, judgment of justice, that was single bench, justice, single bench, appeal was there preferred. nature of the order is not what is the nature of the order is not concerned we are. Concerned we are whether it's exercising the power in a criminal jurisdiction or not. You go there, appear, you go not to go. That's not, we are not concerned about that. We are concerned what jurisdiction. If you hold no, it's not a criminal jurisdiction, appeal is maintainable. But if you agree with this, yes, it's a criminal jurisdiction, then appeal is not maintained.
Then it will not. If there is no embargo, that it is the right to be considered.
Now, my lord, would love to rise and I think time.
Not that. If you continue, we can continue.
No, I don't mind.
On the medical advice, nothing more than that.
No, I don't mind. I am not saying, but they have come, that's the reason. No, I have nothing to say personal, my lord, that whether